Good afternoon, ladies and gentlemen. Thank you very much for making it here. It was just over 1 month ago when I received a call from FICCI that said this conference needed to be organized within 1 month. And but for anyone staying in London, that is an impossibility, but I was asked to put aside my British hat and put on my Indian hat and put on this show at very short notice. And here we are, we have hundreds online on YouTube watching us, and we have a room full of people. Thank you very much. We also have speakers who have flown in from around the world, so thank you all for making it today. Of course, I would also like to thank Mr. Chawla, who's the Director General of FICCI, without whose enthusiasm this would have been impossible, and Amit Padhi of the Indian Council of Arbitration, and Param Shah, who is FICCI's representative to the Indian High Commission, without whose support, again, the logistics would have been impossible. Every arbitration has a life cycle, and we have representatives on this panel from every phase of the arbitration. Starting with my immediate left, Justice Srikrishna, who needs no introduction, who brings the arbitrator perspective to this panel. To his left, Gotham Patel and Paul Gare, both of whom are partners of leading law firms. Gotham, a partner at Reed Smith, and Paul, a partner at TLT in London. And they will bring the law firm perspective. And of course, Mr. Gautam Doshi, we have two Gautams on the panel, who will bring the client perspective to this panel. I will introduce them further as we go along. We've split this panel into three. So we've got, firstly, a topic which is derivative actions versus arbitration, which basically means when there is a shareholder agreement, there tends to be a clause that says, in the event of a dispute, matters will be arbitrated. One party tends to invoke arbitration, but the second party might and often goes to court in their local jurisdiction and says, hang on a minute, this has nothing to do with arbitration. This is all about shareholder disputes or disputes between directors and shareholders of a local company. So can you please, the court, adjudicate this matter? And that is what is a derivative action. It tends to be called oppression and mismanagement in India or unfair prejudice petitions in the UK. There also, therefore, stems two legs of the proceedings, and there is a need for anti-suit injunctions and so on, which we will discuss through the course of the panel. If we may begin with Justice Srikrishna. Justice Srikrishna started his career as an advocate 60 years ago in 1962 at the Bombay High Court. His specialization was labor and industrial law before he was elevated and retired as a judge of the Supreme Court of India in 2006. He has since then been a sought-after arbitrator and arbitrates high-value and complex international commercial arbitration. He's also chaired, as we have heard during the plenary, his name taken not once but 3 times, because he has chaired the Committee on Reforming and Arbitration in India and institutionalizing arbitration. He's also worked on revamping India's bilateral investment treaty laws, and always keeping up with the times, Justice Srikrishna has chaired also a committee to usher in data protection laws in India. On a personal note, he had inaugurated my chambers in Mumbai, and I remember very sheepishly calling him to say, it's on the 3rd floor, there's no lift, it's a heritage building in Fort. And he said, oh, don't worry, it will keep me fit and healthy. So that's Justice Srikrishna for you. Justice Srikrishna, if you may, please discuss the various characters of shareholder disputes, which of them are arbitrable, and perhaps what one can do when a third party that is not a party to the shareholder agreement is caught in the dispute.
Thank you, Karishma. The bane of democracy is when people gang up on a poor minority shareholder. So that is why it is necessary to have a sort of a protection so that the rule of law in corporate jurisdiction is not emasculated. Therefore, you have this company law jurisdiction always. In India, we call it a situation of oppression and mismanagement. So as individual shareholder or a minority shareholder group should not be squeezed out or brought to ruin on account of some kind of deliberate or reckless acts of the majority. Now, this dispute may, as you pointed out, Karishma, that may have two aspects. One is a pure shareholder contractual dispute, which is capable of being adjudicated by the civil court or by an arbitral tribunal. Or it may take the shade of the company court interfering and trying to bring about some kind of a semblance of management. So it may involve situations of dismissing directors, inducting of new directors, change of management, compelling somebody to sell the shares, compelling somebody to buy the shares, etc. Now, if it is a situation where you have to interfere with the composition of the tribunal, composition of the company, or with regard to the management rights, I do not think that an arbitration would be possible at all. At least in India, it would be completely within the jurisdiction of the company law tribunal now, because of the provisions of the statutes. But if it is a simple question of a dispute between a shareholder and a shareholder, which does not involve management of the company or reconstruction of the company's management and shareholding pattern, then it is something that can be capable of being adjudicated before a civil court, or if there is an arbitration clause in the shareholders' agreement between an arbitral tribunal. So this is the basic groundwork which distinguishes a situation which should legitimately be arbitrable and legitimately be non-arbitrable. I can give you an example which really complicates the issue. So you are right, anti-suit injunctions are exactly the situation where somebody says it is not arbitrable and therefore you are wrongly gone to this court. When it is a cross-border situation, you have to look at what is the law that is applicable, the governing law, to what extent is the lex arbitri applicable, and then draw a balance between them. I'll give you a simple situation with a fact situation. You have a majority shareholder and a minority shareholder, under which the minority shareholder, because of his technical expertise, is required to be appointed as the managing director, and his group is to manage the operations. Somewhere along the line, the majority decides to ditch him. So they commit a breach of the contract. Breach of contract is a fact, accepted fact. The interesting thing that happened is, then what happens to the value of the company's shares? The minority shareholder says, had I continued as the man in charge, I would have brought up so much prosperity to the company, I would have done this deal A, B, C, which you fellows have failed to do. As a result of it, the company's share value has gone down. Therefore, I am entitled to damages from you for the difference in the share value from what would have been ideally possible and what has happened as a result. Please note, he is not talking of mismanagement. He is not talking of operation. Therefore, there was no way you could have gone to the company law administration. This is a pure and simple contractual dispute between the majority and the minority, but with this added twist that what is called compensation for reflective loss. What is reflective loss? There is a famous judgment of Lord Justice Bingham here, which says that when a company is caused a loss, no shareholder has the right to move the court. It is only the company which can sue for it. Now, that was long ago. Law has been now considerably departed from in New Zealand, USA, and finally the House of Lords here saying that no, it's possible to do it. And the only reason why the English courts gave a decline to interfere in such matter at the instance of a shareholder was, that it would give rise to multiple proceedings. The company would also be entitled to sue, and the shareholder also would be entitled to. That is where this question of derivative action comes, where the company is entitled to sue, but the company will not move because it's dominated by the majority. The Indian law at least allows him what is known as a derivative right. That means saying that if you have X percentage, prescribed percentage, I believe it is 10%, of the shareholders are together, they can force the company to act on behalf of them, and that gives rise to derivative remedies. Now, on the question of reflective loss, I don't think the law has really progressed so much in India that a shareholder will not be able to say that had I been in management, the share value would have gone up. It has not gone up, therefore I am entitled to damages for the difference. because it is the result of a breach of contract. So this is some aspects of law which need careful consideration. In fact, one of the issues, I must say, I'm saying this from my experience before the tribunal, was whether the doctrine of reflective loss had found its roots in Indian law. After examining all the extant Supreme Court judgments and the High Court judgments, the tribunal decided that there was no such thing, and the law is far behind on the question of reflective loss, and it was not possible to just jump into the situation of what the New Zealand court did or what the American court did. And therefore, we left it at that and said, yes, it's not a situation where the shareholder can be deprived of his remedy. He is entitled to it, and he is entitled to damages. So this is some kind of a nuance that I'm bringing somewhat of a spin to the derivative action situation.
Thank you very much, Justice Srikrishna. And I think it would be well supplemented if we get the client perspective, please, from Gotham Bhai Doshi. So Mr. Gotham Doshi has been a leading chartered accountant in Mumbai for over 45 years, and he has been actively involved in conceptualizing and implementing a number of mergers and restructuring transactions. He acts as an advisor to Indian companies that are in the top 20 listed companies and some FTSE 100 companies as well. He also serves as an independent director on the boards of leading Indian companies such as Sun Pharmaceuticals and Piramal Capital. Gotham Bhai, could you please give us the client perspective on what Justice Srikrishna has just said? And do you think that clients give some thought to derivative actions, or do they jump into arbitration?
Thanks, Karishma. Interesting point which Justice Srikrishna was making. And there is, of course, this issue whether even management rights can be contracted for. And if they are, then whether that is a contractual dispute or it's a dispute which has what you would call effect in rem and therefore should go to the company court rather than to an arbitral tribunal. But clients, especially when they are drafting their agreements, would be very careful as to decide what should be the level of the contract. And at least in India, I have found shareholders' agreements, namely the articles of association, rarely having an arbitration clause. So if there is a shareholder dispute, that still has to go to the company court because it does not have an arbitration clause. The arbitration clause is found in separate shareholder agreements, if at all they are there, by and large, when we are talking about groups of shareholders who have an interest in the company. And then we are talking about a dispute between two groups, which is naturally arbitrable. But something which affects the company should also be arbitrable. The question is, how does the tribunal give an award which will also benefit third parties? And I think that's something for the future. We have to look forward to that as to how it's going to change in the years to come, whether an arbitral award can become something which goes beyond the two parties in the arbitration. That's what we will look forward to.
Thank you, Gotham Bhai. Sorry, Justice Srikrishna, did you want to speak of, allude to perhaps joinder of non-parties to arbitration agreements before we move on?
On the two issues arise here. One is joinder of non-parties to an agreement. Now, this has become a controversial issue, I must point out, that the Supreme Court in that Chloro Control, I think if I remember rightly the name of the judgment, Supreme Court said, hey, if there are situations where one contract is intricately interwoven into another contract, even if the second part, the other party is not a signatory to the arbitration clause, it is possible to rope that party into the arbitration. So three situations are pointed out: the group companies doctrine, or the companies or group companies doctrine, then the situation of back-to-back agreements, then the situation of alter ego of the company. Now, all of them have their drawbacks. It is not so simple, and I must say that the Supreme Court itself was worried that it's stretching the law too much, and the Supreme Court has admitted petitions for consideration by a larger group, and the matter, I'm told, has been directed to the Supreme Court to be placed before a larger, thank you ma'am, a larger bench for reconsideration of the issue. So at the moment, of course, the three theories operate. Now, what is group companies doctrine? A group company doctrine, say for example, there is a company like X, I will not name companies, which has so many associate companies, 25 associated companies, each one carrying on a pretty different business. Can you, of course, there is no doubt that they are a group of companies. Can you say that the cement manufacturing companies' arbitration should be enforced against the chemicals manufacturing or the textile manufacturing just because they happen to be a group? Now, therefore, to what extent will it apply? To what extent will this concept of alter ego apply? That alter ego is something that has been picked up from private international law. If you remember, in the case of enforcement of contracts, where one of the foreign alien in Etbor, it was picked up from there. Now, how far it will apply is another $1 million question, which will have to be resolved ultimately by the Supreme Court of India. And all of them are really pending, and one of these days we'll have an authoritative expedition of the law, hopefully sooner than later.
Thank you very much, Justice Srikrishna. I think there is also a stark difference between jurisdictions and insofar as joinder of non-parties. For example, a number of civil law jurisdictions tend to offer or be more amenable to joining non-parties to an arbitration, but England is not. England does not take that view. Moving on, if I may, to Paul. Paul is a partner at TLT. TLT has been a favorite amongst Indian banks. And from my experience, I should add that one of the first cases I did in England nearly 13 years ago had TLT as my opponent. And one of my most recent cases also has TLT as my opponent. TLT's work includes a lot of banking and fintech, insolvency and restructuring, and enforcing arbitration awards as well as enforcing court judgments. More recently, TLT was successful in representing the State Bank of India together with its consortium of banks on the Vijay Mallya bankruptcy proceedings at the High Court in London. TLT has also been appointed to advise the UK government on its free trade negotiations with India. Paul, would you like to bring in a spin to this angle and perhaps discuss funding? Is it possible for shareholders to have their disputes funded by a third party? What are the advantages and what risks, if any, should they be aware of?
Thanks, Srikrishna. It's an area, and third-party funding, I know, is a topic, and I was speaking about a month ago at another conference focused very much on India-UK disputes, and we had a session there, as is often the case, on third-party funding, and I know it's a very hot topic at the moment in India in terms of application of the ability to acquire third-party funding in order to pursue your disputes. But from an English law perspective, the last 5 or so years, we've seen an enormous increase in both the number of funding options available, the number of funders in the market, but also the number of parties who are now looking to take an interest as that. As Karishma mentioned, we have a very strong financial services practice, and taking a step back, it would seem perhaps the last sector that may look to funding in terms of pursuing its disputes. It obviously has great resource in terms of its own ability to pay the fees and meet the fees of any dispute and arbitration. But we're seeing increasing interest from our clients across the board, including our financial services clients, in terms of the products that are available in the market at the moment. And it really does provide an ability for, particularly in some of the disputes we're talking about here, where you perhaps have an individual who has less resource, less ability in order to pursue that challenge that they have as the derivative action challenge, that they would look to a third party who may be able to support them through that process. There are now, as I say, a range of funders available in the market who are providing those options across a variety of different ways in which they'll provide that funding, from the more traditional pure funding basis where they'll pay for your fees as they go along, all the way through to acquisition of rights in actions as well. So that there is now a real strength of market in the UK, and we know from the conversations that we have with a number of funders that India is a market they are equally interested in, and was sitting yesterday at a conference on opportunities in Gift City, and noticeable that the regulators there mentioned a shopping list of elements they wanted to put in place from a disputes perspective, and certainty and clarity around the ability to access third-party funding was one of those on that shopping list. So it's something that is on the agenda. It's not going to go away. The challenge with it, and I think this is the great difficulty at the moment, particularly in some of the arrangements that I've seen, is around the price point, around the understanding of what it means in terms of the return from funder, the return and expectation for the party who is seeking to take the benefit of that funding model as well, and aligning those two positions in order that there is greater buy-in to it, I think is at the moment one of the challenges. Obviously then ensuring you're getting your terms correct. The position here is much clearer in terms of Champetier maintenance and how you would manage those issues, but ensuring that you understand from a party's perspective who is looking to acquire that funding, what that means in terms of your obligations. And I think equally, and this I think is probably something that is reflective of this wider discussion, also understanding what the exit points are, and understanding how parties may, if they decide that they want to cease that funding arrangement in due course, what those options and what those challenges will be at that time. So it's something, as I say, in summary, that we're seeing an awful lot of interest in at the moment. I don't anticipate that's going to change given the numbers entering the market as well at the moment, and it's one that I think we'll continue to see grow over the next few years.
Thank you very much, Paul. Gotham, if I may, Gotham Bhattacharya, if I may turn to you. And Gotham is a solicitor who qualified in 1993. He's been a partner at the international law firm Reed Smith, and also sits on their global board, which acts as its executive committee. He chairs the firm's India group, and I know from personal experience that he has been a household name for India disputes in the UK for many years. He was the first person I was asked to meet when I had relocated to London. And you know that time when nobody knows you, nobody wants to meet you because you are a nobody? That is when Gotham agreed to meet me not once but twice to give me some career advice. And he has also acted last month on a $1.2 billion case before the Commercial Court in London, acting for Indian banks, that is going to trial next month. I know that Gotham is also a champion of gender diversity, and Gotham and Justice Srikrishna organize the GAR India conferences, and those are, I think, one of the only conferences where I have seen every panel not just having one woman on the panel, but 50% of the panel constituting women. So again, that is Gotham Bhattacharya for you. Gotham, so I think let's take the life cycle of the arbitration forward. So the arbitration, the shareholders have considered whether or not they should go to court, whether they should arbitrate, whether they should bring in funding. Let's say that now there are two legs of the dispute, one in a court and one in arbitration. Is anti-suit injunction something that you would advise your clients? Can you tell us a bit more?
Absolutely, and good afternoon, everyone. In two quick things in a preliminary way. First of all, Karishma, despite meeting me twice, you've done really well. So, so I'm glad that at least you got over meeting me those 2 times, first of all. Secondly, it's an honor to be next to my mentor, Justice Srikrishna, who's a dear friend of many of us in this room, and who I'm very proud to say is my mentor. Yeah, Karishma, this is a very topical area. I mean, anti-suit injunctions are a very active weapon, and a weapon that should be utilized. You always go to what the contract says. So if the agreement under which the shareholders dispute or the acquisition dispute refers is, states that arbitration is the dispute resolution mechanism, then that's king and queen, right? You can't stray away from that unless the dispute is not caught by that agreement and is caught by some other agreement. That's where Antisuit injunctions are very powerful. As I'm sure everyone will know, an Antisuit injunction is not directed against a foreign court. It's directed against the other party to stop or refrain from taking on proceedings in a jurisdiction they shouldn't be in. And the English courts will utilize that weapon quite regularly. So Section 37 of our Senior Courts Act gives the English courts that jurisdiction. A number of cases, including the Angelic Grace and other cases, set out the test that will be applied. And it's a very well-used weapon. And I suppose many people will know about, I'm not going to do too much on cases, but there's a very well-known case called Malhotra and Malhotra, which involved Indian parties in the English court, in which on an ex parte basis, the High Court granted an Antisuit injunction to refrain certain Indian parties in a family dispute, it must be said, in India, from pursuing company law board proceedings in India and other proceedings. When it came to a full hearing, the English court discharged the Antisuit injunction on the basis that the arbitration agreement did not cover all disputes between the parties. It involved a complex mix of agreements, a complex set of facts. So clearly, whilst the weapon exists, it's not going to be used when it shouldn't be used. But it's very important to use when you can, because some parties will try to bypass the agreed dispute resolution mechanism and go for a home court advantage, or what they perceive as a home court advantage, or delay, or whatever the motive may be. So the Antisuit injunction can be used to regularize that position. The last thing I'll just say, and in a case that is about 10 years ago now, we got an Antisuit injunction in this case, which ultimately went to the Indian Supreme Court in 2020 for its final leg, the Prismian case, the Prismian and Kara case, and Courier case in the Indian Supreme Court. But here in England, we got an Antisuit injunction to refrain the Indian parties from commencing Bombay High Court proceedings, which would have been in breach of the English arbitration agreement. So it's a very powerful weapon which should be used. It's a discretionary remedy, so it'll only be used when appropriate, but it can be very, very important.
Thank you very much. I think this completes our discussion on the first leg of our of this session, which is derivative actions versus arbitrations. And moving on to the next in terms of an arbitration life cycle, interim applications are ones to surmount as soon as the tribunal has been constituted and the parties are now, in the thick of things. Justice Srikrishna, if I might call upon you, this was a topic that was also alluded to during the plenary. So Kiran Rijiju, our law minister, alluded to the Amazon and Future Group dispute, which was on emergency arbitrations. That is, of course, one type of an interim remedy that parties may seek. Do you think, Justice Srikrishna, that the Indian court's approach has changed after the Delhi High Court's decision in Raffles design? Can you tell us a bit more about Amazon versus Future Group?
Yes. Compared to Raffles design, where a view was taken that there was no provision in the emergency of an emergency arbitrator in the Act, Indian Act, the Supreme Court has moved to the extreme right. But I have my own, speaking very academically, I can't criticize the Supreme Court without being most respectful to the Supreme Court. What has the Supreme Court done? Look, the 246th Law Commission report in India specifically recommended and said that it is high time that the law should be amended to include an emergency arbitrator in the definition of arbitral tribunal. That was not done. And the committee which I headed went into the whole thing, and we also strongly recommended, and we said that the definition of a tribunal should be after whatever it was in the originally in the Act, saying that including an arbitrator appointed as an emergency arbitrator if under the rules of the institution. Government did not bring it forth, Parliament did not act on that. Now on this situation, when on 2 occasions Parliament could have amended the law and the Parliament refrained from amending the law, after all, what is the judge doing? The judge is imputing an intention to the Parliament to do this. Can I really say that the Parliament wanted to do it but forgot that, the doctrine of omissus cases applies here? What has the Supreme Court done in the Amazon case? I'm sorry. Hey, look, Section 17, which, interesting thing, Amazon was a situation where the governing law is Indian law, but the proceedings were before the Singapore SIAC, Arbitral Council. Now, under the rules of the SIAC, there is a provision for emergency arbitrator. So the emergency arbitrator was rightly done in an interim award. He called it an interim award was made. The interesting thing is, under the Indian Arbitration Act, Part 2, which applies to international awards, does not recognize an emergency award at all. This is because even under the ancestral New York model, there is no such recognition of that. This is exactly so in India because if you look at I think one of the speakers earlier referred to Section 44A of the Civil Procedure Code. What does the Civil Procedure Code recognize? It recognizes a final decree under a reciprocating territory. Like, for example, the India and UK have a reciprocating agreement. So every decree in England is enforceable in India and vice versa. But that does not mean that every interim order is enforceable. This is the logic that has flown through the New York, the ancestral model and into the 96 Act. I'm not saying you can't deviate from that. In fact, I was personally of the view that it should be deviated from. But if Parliament, after taking cognizance of 2 high-placed committee reports, refrains from that, can we still say Parliament intended to do it? Number 1. Number 2 is, the Supreme Court's reasoning in that Amazon matter is somewhat facile, with great respect. The Supreme Court says, hey, the definition does not exclude an emergency arbitrator. Now, if the definition in a statute says A, B, C, there may be 2 million things which are not excluded. Can the Supreme Court say all those are not excluded, therefore I'll include them here? I mean, subject to this, the question of emergency arbitrator will again come up before the Supreme Court, and I'm sure that again the Supreme Court will have to reconsider the whole issue and then go into it threadbare. And perhaps this should have been said before the law minister. It's time that the Government of India recognizes that it is necessary to march in step with what is happening all over the country, all over the world, and then improve the definition of an arbitration tribunal, give a provision under Section 17 for enforcement of arbitration award. And look, ultimately, what is an award? An award is a final disposition of a lease. Now, what is done under the SIAC as an emergency, although it's called an interim award, it is not an award in that sense at all. It is just a plain and simple interim order which should have been passed by any tribunal in India or any civil court in India. To give it recognition across the border is somewhat of, to my mind at least, it's impermissible. Anyway, the Supreme Court has done it. Well, the Supreme Court has been very active in the matter. Let's see where the law ultimately takes its shape. Thank you.
Thank you, Justice Srikrishna. Of course, this is a FICCI event, and no doubt FICCI will take your representations as they tend to do back to the law minister, Gotham Bhattacharya. Does this dilemma also exist in England and under English law? Are interim awards enforceable in England, or is it only final awards that are enforceable?
Yeah, no, this is also a very thorny issue. And there's no doubt, I mean, let's take emergency awards as the example. These are a very well-known, well-trodden path. They're very common. Virtually every arbitral institution has a mechanism for emergency arbitration. And sometimes you need to use that because you need to get urgent relief. There's no doubt about that. Some jurisdictions enshrine in law, in statute, the ability to enforce an emergency award. Hong Kong is one example. Hong Kong has an explicit provision in its ordinance which allows the enforcement of emergency awards from another jurisdiction. English law does not, and I'll just explain briefly a little bit about this. But before I do that, there was one comment in the opening session which Ms. Luthra mentioned that I thought was very telling, which is that we in England feel very proud of our arbitration reforms and that our 1996 Act is a wonderful paradigm. But the fact is, as Ms. Luthra rightly said, it's never been reformed in law, whereas India has had multiple iterations. Now, we can debate that in a separate session, but the point I make here is that in England, there's no explicit authorization for an English court to automatically enforce an emergency award. Now, my view, which is also a view that I happily share with a number of very well-known commentators, including the late, great Johnny Vida QC, Gary Bourne, and Albert Vandenberg, and others, is that emergency awards should be given greater enforcement. Now, in England, under Section 66 of our Arbitration Act, in my view, an emergency award would qualify as an award. And it's not yet been tested. There's no reported case. We almost had one in a case that I did last week, but we didn't get the decision on this point. It was just dicta. But the point being is this: an emergency award is an award for the purposes of Section 66. An award will be called an award, and many institutions will register that award in their register of awards as an award. It looks like an award, it is an award. English law has two cases which stipulate what is the distinction between an order and an award. There are two cases in the commercial court, one of Mr. Justice Cockerell called ZCCM Investments, and last year in a case of Mr. Justice Butcher in a case called Uganda and Rift Valley Railways, which make this distinction very clear: what's an award, what's not an award. So now what English law needs to do now is have a decision, a reported decision, which explicitly enforces an emergency award. These sorts of reliefs are incredibly important. Very often, the emergency relief is as important as the final relief that you're seeking in the arbitration. And that shouldn't be lost on the arbitrators or anybody involved in the process or the court involved. But courts need to have the jurisdiction to make that. And there has surprisingly yet been no reported case in English law of which I'm aware where an emergency award has been actually enforced here. Now, the time will come. It's very important. And there are, and if you look at litigation, which is very often a very useful reference point in these sorts of things, the English court will enforce a freezing injunction made in another common law jurisdiction without any problem. So there's no reason why conceptually you couldn't adopt exactly the same principle to arbitral emergency awards, especially when a number of those awards do make injunctive type relief. So there are lots of bases as a matter of jurisprudence to say that you should enforce. So, but it's yet a gray area, a bit like my hair, Karishma, it's very gray.
Thank you, Gotham.
Time to color it either white or black.
Yeah, well, I'll try.
Not your hair, I mean the law.
So, as we discuss coloring the law, either black or white, but at least there is ambiguity in both countries. And turning now to Gotham Bhai to get the client perspective on this, which is actually slightly different from the law on this point, because I think Gotham Bhai tells me that he has had success in enforcing an interim award in India. But before I hand over to you, I think there are further threads that connect what Gautam Bhattacharya has said and what you are about to say, which is on the Malhotra and Malhotra matter, which Gautam, you alluded to earlier, where the commercial court in England lifted an anti-suit injunction that it had imposed ex parte, allowing India's then company law board proceedings to continue. And that was upheld by Justice Patel of the Bombay High Court and is a very good example of comity between the two nations, of what can take place when the arbitration is still not really progressed to its trial phase and is still at the interim phase. But back to you, Gotham Bhai, on your experience of enforcing interim awards.
See, as was, said by, it is certainly a gray area as to whether an interim award can be implemented as an interim award. One has tried, but what one can do, and perhaps courts would agree, is a Section 9 application in India requesting the court to pass virtually the same order as its order, what is there in the interim award. And that is the interim injunction, because the court has the power to give that injunction. So one achieves the same purpose. One gets an interim award, maybe from the tribunal, and gets it converted into an order of the court, which can then be enforced. And at least in the Malhotra versus Malhotra matter, to an extent that is what happened, because that was what the two parties agreed to even by consent, that they would agree to that enforcement. So enforcement is, one has to find, because I think, as was mentioned in the opening session, this is an era of instant noodles. And therefore, this is an era where one cannot wait if emergency awards and interim awards are not implemented. One has to find a solution. And perhaps a Section 9 application in India may be a way out.
And Gotham Bhai, what kind of interim award was it? What was it trying to enforce?
It was trying to enforce two things, a non-compete, and also trying to, therefore, as a part of that non-compete enforcement, trying to stop the other party from carrying out manufacturing operations at their location, which was under their control, physical control. The ownership was in dispute. And by putting in a freezing injunction on the plant, machinery, etc. In practice, if I may just add, the difficulty was, even after the High Court passed the order, it was difficult to get it enforced by the local authorities before where the factory was situated. The High Court's order does not necessarily carry enough writ before those local authorities. So it didn't really work.
So that remains gray. We're still not in black or white. But we've done India, England, India, and now Paul, if you can give us the English perspective. In particular, what are the public policy considerations when enforcing an award that may have been illegal in the country of the seat?
Thanks, Krishna. The English law interpretation on public policy is narrow, and I think that's the obvious start point here, outside of universally condemned fields such as terrorism, drug trafficking, or where there's a fraud or corruption involved. So to bring a challenge on that basis will inevitably be quite difficult. It would be a particular case that would turn on its very facts in order to be able to get home on that particular limb.
Thank you, Paul. I think there are also recent English court judgments. So there's a Coot Foods matter that has been already pronounced in England on this topic that follows Enka and Chubb, which is, I believe, contrary to the Coot Foods, the same matter before the French courts. Both have taken opposing views. Maybe I can just wind up this leg of the panel and discuss very briefly summary judgments, because this is also relatively new to arbitrations. So summary judgments are traditionally granted by Indian courts under Order 13A of the Indian Civil Procedure Code, and are similarly granted in England under Rule 24 of the English Civil Procedure Rules. They tend to be a robust tool to curb unnecessary trials. So for example, if there is a lender that has lent money and there has been a default on either a bill of exchange or just a simple loan or a guarantee, there isn't much of a defense and there is no need for the matter to progress to trial. It would be sufficient for it to go to a summary judgment and for a summary judgment to be granted. But the question is whether that can also be granted in arbitration, and would that be in the interests of justice, given that arbitrations tend not to have a leg of appeal that opens things up in the manner that an appeal does if one were to go to court. There are conflicting decisions on this topic as well. So for example, a Singapore decision has disallowed summary judgments in arbitration, but an English court decision, in fact, involving an Indian party, Uttam Galva Steels against Gunvor, has upheld summary procedure in an arbitration. Moving swiftly on to the last part of our panel, and this is the changing nature of arbitration, or rather of shareholder disputes. So just as the remedies, as we have seen, for being granted in international arbitrations have changed, so has the nature of shareholder disputes. When we were preparing for this panel, we discussed how a few years ago, what would land at our desks would be what are just regular brick and mortar or just regular shareholder disputes. But now about 30 to 50% of them involve an element of technology. Either the revenues are tech-driven, or it's a tech-driven business that has had that investment. With this in mind, if I may call upon Gautam Doshi, what has your experience been with shareholder disputes in the technology space?
As you rightly put it, I think the atmosphere is changing in the because of the technology space, because unlike the tangible business, where a degree of evidence is available, a degree of certainty is available on the value of what you are disputing, namely the property, the plant, etc., and the business. In the context of technology, you are in a very, very subjective area. The valuations are difficult. You additionally have the difficulty of the corporate governance systems and the accounting systems, which have developed, but perhaps have not sufficiently captured the new modes of business. And therefore, the question as to whether the accounting was erroneous and certain expenses which should have been written off or not written off, or certain incomes wrongly accounted, etc., which would not be so difficult in a traditional case, whereas it would be very difficult in the context of technological issues. And therefore, the extent of disputes on accounting, one has found, has significantly increased. The allegations on corporate governance have significantly increased. They have still to get result into awards and tangible awards and orders, because I think it is still nascent, this area of dispute. But one is seeing a complete change in the amount of evidence being collected and the nature of the evidence required to be presented and proved, whether it is before a tribunal or a court.
Permit me to say something on this. Look, traditionally, non-material assets were considered to be the intellectual property rights. As it is, even traditional valuation of the IPRs is quite a difficult task. As Gautam Bhai rightly pointed out, the IPR of a company which is well run is differently valued from an IPR of a company which is ill run. Now I'll add another dimension to the problem. Most of the companies are sitting on a whole lot of data, some of which may be personal data, some of which may be non-personal data. Now, how are you going to value the data is going to be a big problem, as and then, of course, our parliament gets down to the business and brings in some kind of an enactment. Even then, from the perspective of valuation, it is going to be a big issue. Whether having this kind, for example, a company may have a lot of data with regard to material sourcing, with regard to financial sourcing, with regard to its distribution chains and the value chains. Now, how much of it is valuable, how much of it can be valued at what value is going to be a big issue, and the technology is going to bring this issue by sidebind, and I'm sure people like Gautam Bhai will have to work hard to sort out this issue.
So I think what we take away is that it's no longer a regular breach of a clause in a shareholder agreement, but one needs to delve a lot deeper to try to determine what is it that has gone wrong in order to get the matter off ground. Paul, would you like to have the last word on this, on perhaps TLT's fintech space?
Yes, I was just going to say that I think reflective of this change that we're seeing and obviously the development of sectors such as the fintech sector that we have a particular interest in. April last year, the UK Jurisdiction Task Force published the digital dispute resolution rules that were a step forward in terms of management of some of those disputes and looking at some of these asset classes that we've been talking about. There are a set of arbitration rules that are effectively to govern disputes in disruptive novel technologies, but they give, and obviously, firstly, worth saying that or important to say that the parties would need to incorporate those into their arbitration agreement. They would be subject to English law, but the interesting element of them is they give certain powers to the tribunal to operate, modify, or sign digital assets relevant to the dispute, or indeed to direct one of the parties to do the same, which is reflective of the emergence of cryptocurrencies, etc., or crypto assets. And I think that progress and that change is something that is really welcome in terms of the fintech developments and the technological developments that we're seeing, having rules that adapt to those technologies as well, such that you are able to manage and police some of those agreements more effectively.
May I add one more spin to it? Yes. What happens if cryptocurrency becomes acceptable as a part of commercial dealing? Now, evaluation of that is going to be much more complicated than your ordinary fiat currency. At least you have fiat currency, you know what it costs, £1,000 or £1,000,000. But with cryptocurrencies, the valuation today may not be the valuation half an hour later. So how are you going to deal with such situations? Gautam Bhai, take notice.
Just a very brief one.
Yes,
I'll just make a very brief point. You know, just to pick up on something that Justice Srikrishna said and something that Paul said, because I think this is a really interesting area where there's going to be a lot of development. The first thing is expert evidence in this area has to develop, right? We all know that experts owe their duty to the court or the tribunal, but how many experts are expert in this area now in terms of really on a forensic level going into the ins and outs, the weeds of this? I mean, that's one thing we have to keep a watch on. Secondly, also, and this is maybe a little bit controversial, but we expect arbitrators or judges to understand all of this technology. I actually don't think that, you know, there's that level of sophistication just yet. And so one of the things we all have to be very mindful of, in the same way that if we have engineering disputes, and Edwin, for example, and you, Srikrishna, come from a chamber that's very well known for engineering and construction disputes, you've got a very specialist field there. Well, crypto, fintech, whatever you want to call it, blockchain, I mean, you know, I don't understand half of it, right? Or more than half of it. And so when you talk about this from arbitrators, they need to be very sophisticated in this area.
I think leading on from this is also the essence of all of these disputes, which is if the crypto fraud has not arisen between the exchange and the owner of the crypto, but is between a third party, then how can those disputes be arbitrated? And just to take on from what Justice Srikrishna has said, in fact, we were in exactly this spot. So I was instructed in a matter where we froze crypto on the last court working day before Christmas. But a few months on, the valuation of that crypto has dropped dramatically. And therefore, the amount frozen is no longer compensatory to the individual that was defrauded. And these are issues that courts in England are grappling with. I must say also that the courts in England are doing a stellar job of really taking this jurisdiction forward as far as crypto fraud is concerned. But if I may now sort of wind up, because we've got another session before lunch, and by doing, maybe with an anecdote, so I was preparing for one of my first Court of Appeal hearings, and this was in my previous chambers where my ex-head of chambers said, it's a bit like conducting an orchestra. You have to get some of the instruments to play and continue playing at a higher volume, and you have to let the others fade in the background. So I think the audience will join me in saying that this panel has produced a melodious outcome. And thank you very much for being here today. Some of you, thank you for flying down as well.
No orchestra can be successful unless the conductor is. Thanks to you, Karishma, for conducting it beautifully.